Well, it started as an idea in a classroom and ended up at the International Court of Justice. The court is currently hearing arguments about whether the world's biggest emitters are responsible for protecting the climate from greenhouse gases. Its findings could change how successfully smaller states are when they take big emitters to court over their alleged failure to protect them from the climate. Margaret Young is a professor of law at Melbourne University and says the case will highlight the importance of human rights treaties.
So the International Court of Justice is the principal judicial organ of the United Nations, sitting at The Hague, and it hears disputes between countries, but it also has a so-called advisory jurisdiction, which means it can give an advisory opinion on certain legal questions. And those legal questions have to be asked by a UN organ or agency. Here, the General Assembly passed a resolution requesting this advisory opinion, and it was Vanuatu and a group of Pacific Island countries that really were the force behind that resolution passing at the General Assembly, although we did have a majority of states ultimately supporting that resolution. That was back in March in 2023.
And the hearings have begun at the ICJ. What are we expecting to learn from them?
So the court will be considering the legal issues of this case. And the question that's been posed is in two parts. So the first is to ask about the obligations of states to ensure protection of the climate system from greenhouse gas emissions. And the second is to ask about the legal consequences of these obligations. So, for example, do states owe something to other states who are especially vulnerable to climate change effects, like small island developing states? Or do they owe something to future generations? And what are the consequences? Do they have to cease the wrong that's causing this significant harm now? Do they have to pay reparations and so on? And I think what's important to emphasise is that these issues go much further than the United Nations Framework Convention on Climate Change and the Paris Agreement. So these are the climate treaties that we hear so much about, which have set a really important temperature target. So that's the idea that states have come together to resolve that global warming will not exceed 1.5 degrees above pre-industrial temperatures. That's been resolved within the climate treaties. But the question here is, do the obligations go further than that? Because we have human rights treaties, we have a Law of the Sea Convention, we have obligations that arise under international environmental law about not causing harm to a neighbouring state or to areas beyond national jurisdiction through pollution. So once you're thinking about these broader issues of international law, the question is, well, perhaps we need to think outside the box, outside of just what the Paris Agreement and the UNFCCC tell us is the law.
And if this is the whole point of it, what might these hearings then lead to? I suppose many people want to know if there will be a possible tangible outcome.
Yeah, so immediately we have the next 2 weeks of oral hearings, and this has been, I guess, an unprecedented level of engagement by states and relevant international organisations. They've made written submissions to the court. They're appearing now at The Hague over the next 2 weeks, presenting a lot of evidence about climate harm and also about the content of this public international law outside of the Paris Agreement and the UNFCCC. Ultimately, it will be the court who gives us its advice. So it will interpret all of this law. It will consider all of the evidence. What it will give is an advisory opinion that's not binding on states. However, it does provide some legal certainty about existing obligations. That might influence a whole other set of proceedings, whether they be contentious cases before the court, or indeed whether this advisory opinion will influence domestic courts who themselves are considering a lot of climate litigation at the moment. There are also regional courts around the world that are considering climate cases. So it's considered that this apex court of the United Nations is going to be highly influential within the context of other legal processes worldwide.
Yes, but can one realistically expect the large polluting countries to be held to account? And in our region, it's us here in Australia, because the delegation or the submission by Australia has said that obligations for nations to prevent climate change largely did not extend beyond the major international climate treaties we spoke about earlier, including the Paris Agreement.
That's right. So there's a real tension here to ask, when states come together to look at greenhouse gas emissions within the climate treaties, have they covered the field, or are there other developments that we need to pay attention to? For example, we know in biodiversity issues, so the health of plants and animals and ecosystems, there's a whole other convention on biological diversity, which also just had a conference of the parties, and which has recognised that there's significant harm that's being caused by rising temperature to a whole range of species. And they've been asking, well, perhaps within our treaties, there's issues that we have to deal with because our mandate has been to protect biodiversity. Equally, human rights treaties have become extremely important in the climate context because we're seeing that communities have their cultural rights, their livelihoods, their just ways of being really impacted by rising temperatures, extreme weather events, and sea level rise. And so if this is the case, then those human rights treaties, which states have agreed on in order to protect human rights, really ought to play a role.
And is that being boosted by the fact that, some of the other major polluters, the US and China, are making submissions in these hearings despite both countries not recognizing the authority of the ICJ?
Well, I wouldn't say that those countries don't recognise the authority of the ICJ. It is the principal judicial organ of the United Nations. What they may not do is recognise compulsory jurisdiction of the court, which means that if a country has a dispute against the US or against China, it might decide, we're not going to turn up. We don't actually agree to this dispute being raised against us. That's the contentious jurisdiction of the court. In the Australian context, Australia does accept the jurisdiction of the court. So Australia sees it's much better to have a system to resolve disputes around the world than to not have one. And so we have agreed to what's called an optional clause saying that we will consent to appearing before the court if a case is brought against us.
Okay, Professor Margaret Young, really good to get your legal insights into this. Thank you so much.
You're welcome. Thank you.